So patent licenses, you can have different types of license agreements. One of them can be an exclusive license and one of them could be a non-exclusive license. Now, these types of licenses are not limited to patent licensing. You can also license technology. You can license what's called know-how, which is how you use a certain technology or how you manufacture a certain product. You can license products that are not patented. But I'm going to talk about this generally in the patent licensing context, but it is applicable to other types of licenses, not just patent licenses. An exclusive license. With an exclusive license, in general, you're going to have only one licensee. So one entity is going to be licensing from you whatever that patent is. But that's not necessarily always the case, because you can have non-exclusive licenses that have an exclusivity in terms of a certain provision of that license. But we're not going to get into the details of those types of agreements in this video. One other thing to understand about an exclusive license is that in most cases, usually there will be some limitations put on that license. In other words, the limitations could be limiting the exclusive license by location, time, or market or field of use. And there could be other limitations as well. But by location, for example, you might limit the licensee to using or selling the patented product only within certain states in the United States. Or if it's an international deal, you might limit that licensee to selling the licensed product only within the boundaries of the United States, but not in other countries where you may have patent rights. The term of the license could be limited to a certain number of years rather than extending out the entire term of the patents that are being licensed. The market or field of use. Your patent may be applicable within different areas of the market or different areas of technology, and you may limit the licensee to using the patented subject matter only for a certain market segment or for a certain technology segment. So let's say, for example, you have a technology that might be applicable to radios, but the technology that's applicable to radios in one context, such as a mobile device radio, might also be applicable to radios in an automobile. However, you've decided that for this exclusive license, you only want the licensee to be able to sell the patented product or use the patented invention with respect to mobile device technology, but not a radio device, although it could be mobile, within an automobile. So that would be one type of market or field of use limitation. Now, a non-exclusive license. In general, you will have multiple licensees, or you will have the ability to have multiple licensees. So, for example, initially, you offer one licensee a non-exclusive license, and later on down the road, you offer a similar agreement to other licensees, and you add to the pool of licensees that are making, using, and selling your patented product. Now, even though that agreement is non-exclusive and you can have multiple licensees, you may still have limitations based on location, time, or market and field of use. So there's many possibilities for what that non-exclusive license agreement may look like. But to summarize, in general, the difference between the exclusive and the non-exclusive is that with the exclusive agreement, generally, it will be licensed to a single party, and with a non-exclusive license, you will have the ability to have multiple parties licensed that can all make, use, and sell the product, and therefore you can have multiple entities producing royalty revenue for you. Now, one other thing to understand about an exclusive license is that an exclusive license may have a provision within it to convert it to a non-exclusive license. Why would you want to do that? Well, let's say that you're not sure if that licensee is going to produce sufficient sales or sell enough products for you to obtain the level of royalty payments that you expect over a certain period of time. So under those conditions, you might have a clause in the contract that states if the licensee doesn't sell a certain number of products to produce a certain amount of royalty revenue within a certain period of time, then the agreement converts from an exclusive to a non-exclusive license agreement, giving you the ability to go out and seek other licensees that may be able to produce additional sales and the level of royalty revenue that you're expecting.